Thank you, Speaker. This bill has been advertised as a bill to fight domestic violence. And if it really did that, I think we'd all be in favor of it, because domestic violence is a terrible, abhorrent crime. But it doesn't. Nothing in this bill will stop domestic violence, because the gun doesn't do the domestic violence. It's the person that shoots or uses a knife or his hands or her hands or bludgeons. What this bill does do, I think, is fairly dangerous. Our Constitution is a very important document, and it preserves certain rights, constitutional rights. And there is not another constitutional right that is being threatened or can be taken away because someone committed a misdemeanor. A misdemeanor, and you're going to try to take a constitutional right away for a misdemeanor, not a felony. What other right can you think of that is threatened because someone commits a misdemeanor? Let's take one of those rights that is in the Constitution, the right to protest. We know that there are a lot of people who protest, and they are charged with misdemeanors because they disturbed the peace, because they made damage some property. Should we say that those people should not be allowed to protest for 6 more years because they got a misdemeanor charge? That's how sacred constitutional rights are. Which other ones are we going to say you can't have because you've been charged with a misdemeanor? This goes to the heart of what we in America value, which is our constitutional rights. It is enshrined in the Constitution. The Second Amendment. And it's just as important as all those in the First and all the rest. This bill threatens that because someone committed a misdemeanor. So should we take away the right to protest? Perhaps we should put that bill in next year and strip offenders of 6 years of their right to organize and protest. This is a bad bill. It doesn't do what it says it wants to do. And what it does is threatens the constitutional rights of each of us. I urge you to vote against it.
Thank you, Mr. Speaker. You know, Chairman Craven said that 80% of our constituents support this until they find out what's in it. We put a name like the Protect Rhode Island Families Act, and it sounds good. And I think pretty much all of us, if there's a true domestic abuser abusing a domestic partner, a spouse, a girlfriend, or a family member, I think a lot of us would support the notion in this bill. But this bill goes a lot further than those who are in a substantive dating relationship. It extends to anyone who cohabitates with each other. And then it takes away the court's discretion as to whether to remove the Second Amendment rights of individuals. The court shall remove firearms from anyone restrained in district court, anyone restrained in family court, and anyone convicted of a crime of domestic violence. Let's start with the restraining orders. As you know, Mr. Speaker, the standard for restraining orders is not beyond a reasonable doubt, which is the standard for criminal conviction. It's not clear and convincing evidence. It's a mere preponderance of the evidence that the court needs to find to restrain someone in district court or in family court. And then if they find by a preponderance of the evidence that that person should be restrained, the court has absolutely no discretion. It must take away that person's Second Amendment rights. Many of us in this room have fought against mandatory minimums for a long time. This is a mandatory minimum. A mandatory minimum removal of a fundamental constitutional right. So let's look at, it's a long bill, so let's start in the beginning. Let's start with the district court restraining orders for domestic abuse. As I said, it applies to cohabitants. It does not require you to be in a substantive dating relationship. It could be two roommates. One roommate could throw a book at another roommate. That other roommate could run to district court, and if the court finds that the person attempted to cause physical harm, then the court would have no discretion but to take away the person's Second Amendment rights. When we go to family court, it's the same standard as above, attempting to cause physical harm or placing another in a fear of imminent physical harm. These are very vague standards. They're easy standards to meet on a preponderance of the evidence. And now, when we deal with criminal convictions, we have to have beyond a reasonable doubt, a finding of beyond a reasonable doubt, but it now moves misdemeanors into the category of convictions that could have your Second Amendment rights, actually that must have your Second Amendment rights taken. Disorderly conduct is now one. It must involve some type of attempted use of force or threatened use of a dangerous weapon. I'll give you an example. Two roommates, because this applies to people who cohabitate. One could be drunk and take a swing at their roommate. And if the cops come, find that person committed simple assault on a cohabitant, they have to take away the person's firearms for the length of that conviction. And beyond the conviction, actually, until expungement. So I could go on for hours because this is a long bill. The main takeaways: preponderance of the evidence standard, it's very low. No judicial discretion. Fundamental rights are getting taken away. It's a mandatory minimum. And we mostly don't like mandatory minimums unless it applies to guns. So it's a big problem. I'm sure I'll get up again on this bill, but if we were just to limit this to family members and those who are in a substantive dating relationship, I don't think it would be much of a problem. This is far too broad. We need to pull it back. Because there can be a lot of problems that we don't anticipate and a lot of infringements in here that can happen with the application of this proposal. Thank you, Mr. Speaker.
Thank you, Speaker. To address some of the comments that need to be clarified, it was stated that this bill is a compromise that addressed the needs of the opponents. I think we've all received the same letter that clearly indicates this is not supported by the opponents, never was. I also have to correct the statement that a misdemeanor can lead to the confiscation of all your personal property. It doesn't even go that far. A simple appearance in civil court, where you have no right to counsel, by the way, you can lose your personal property and your constitutionally protected Second Amendment rights if you appear in civil court, in family court. And the family court judge is always going to err on the side of caution, as they should, and issue a restraining order. There's no finding of fault. There's no finding of guilt. No one's been convicted of anything, not even a misdemeanor. And their personal property is seized. This is America. In the context of that, think of it. Their personal property is seized. Their constitutionally protected, God-given Second Amendment right is violated on an accusation. That's what this bill does. We heard that 28 states have this same language and that South Carolina just passed a bill with the same language. It wasn't identical language, but worse than that, the underlying statutes surrounding domestic violence in the state of Rhode Island are very different from all of those other states. So while a bill may mandate the same things or similar things to another state, the underlying statutes on domestic violence are different. And I'll give you an example because we have heard cyber stalking, vandalism. So someone gets into a fight with a cohabitant of their house, and on their way out, they don't want to get into a physical altercation, so they decide, I'm going to leave. The smart thing to do. They get out, go in their car, open their door, accidentally ding their roommate's door next to them, they've committed vandalism by the statute. Party 1 walks into the house, and Party 2 is on the computer having an illicit computer video chat with their person that they shouldn't be having a video chat with. And that person gets so angry they walk up to the computer and turn the computer off. Didn't touch the person, didn't verbally assault the person, didn't even say anything to the person. Just turn the computer off. I don't want you talking to your boyfriend on the phone, on the computer. They just violated the cyber stalking statutes. It's not just the bill that we're looking at. We're looking at all of the statutes underneath it that this impacts. Civil libertarians, or people who consider themselves civil libertarians in this room, should cringe at the notion of this bill. Should cringe at it. We just learned the Chief of Police Association in the state of Rhode Island is opposed to this bill. They voted. I have the email right on my phone. They are opposed to this. Why? Because we are going to mandate that they implement a system of tracking all of this seized personal property. They're going to be liable for it. They're going to have to develop procedures for it, ways to track it. They don't have the manpower and they don't have the resources. But yet we're piling on another unfunded mandate to the people who should be on the street protecting us, but are back in the office doing paperwork and taking care of people's seized personal property. And just to correct another thing, we don't have a right to firearms by virtue of the Constitution. We have a right to firearms by virtue of the fact that we're human beings, and that's a God-given right. The Constitution protects it. At this point, I'm done. Thank you.
I'm just going to go through the list of some of the comments that were made. As to the right to counsel issue, I think what my colleague was saying was that in criminal prosecutions, you have a right to counsel where if you can't afford one, the state has to supply one to you. That would not exist in a civil restraining order proceeding. So when you go to the district court and you're poor and you have no money and you're about to have your Second Amendment rights stripped from you, you don't have the right to force the state to pay for your lawyer like you do in a criminal prosecution. I think that's the issue that he raised. As to Representative Knight's comment that with a misdemeanor, we take away liberty interests all the time. Yes, but the court has discretion. Those convictions may be put in jail for 6 months, may be subject to a $1,000 fine. It's very different in this context to say, shall hand in your firearms. It's very different to take away judicial discretion. If some of those misdemeanor statutes said, shall go to jail for 6 months, all of us would have a problem in here because it's taking away judicial discretion. And as to the notion that you have a right to interact with someone when you're restrained, I agree. The court should keep you away from someone who doesn't want to talk to you. I don't believe you have a fundamental right to interact with a third party, but you do have a fundamental right, a personal right, to keep and bear arms. I think it's a very important distinction when the court says, stay away from that person. It's very different than saying, hand over your firearms. Let me see. Yes, as to the points raised by Representative Tanzi, the court can take your property, which I think means the court can tell you you have to leave the common domicile. The court can restrain who you speak with. In all of those instances, the court may do that. The court may take your property. The court may restrain you from interacting with someone. This bill says the court shall take away your Second Amendment rights. I personally think this is a slap in the face to our judiciary. Right now, they have the discretion, which they exercise every day, as to whether or not to take away someone's firearms. They already have that ability under the statutes we're dealing with. The court may take away someone's firearms, just like they may put someone in jail. They may order you to leave the common domicile. They may order you to stop talking to someone. This is shall. And the fact that we don't see that it's an enormous problem to take away someone's rights and not give the court any discretion as to whether to do so or not The fact that we're not recognizing that and we're conflating it with all of these other discretionary decisions on behalf of the judiciary, I think is dishonest. And I think it isn't dealing with the real issue here. Preponderance of the evidence shall take away someone's constitutional rights. Show me where else that happens. Not me.
Speaker, ladies and gentlemen, I actually was not planning to say anything on this bill because most of what I'd want to say has been said very well by a lot of other people in the room. But I did want to address one comment. I've been listening to the entire debate, and I actually think this is a very good debate. We don't have good debates in this chamber probably as much as we should on important issues. I almost called for a point of order at the time, but I didn't because I didn't want to get into back and forth and disruption. But there was a comment made by my good friend, Representative Hearn. We got elected together. I think you're one of the most honest people in here, and I know you're very passionate about this issue, even though you and I don't agree on it. But you said a while back that you're upset that people in this room are defending habitually violent offenders. That's not what this is about at all. Nobody is defending habitually violent offenders. I don't want that soundbite even out there because it's just completely not true. In fact, under existing law, any judge worth their salt is going to deal with habitually violent offenders properly. This bill is precisely going to end up targeting and hurting the people who are the exact opposite of an habitually violent offender. And I'm not going to go through all the examples that have already been given. I don't want to use my full 5 minutes. I actually want to sit down. But the one thing I'm going to say is this. In 2013, after Sandy Hook, those of us who were here, there was a bevy of gun legislation bills that were introduced. And I sat through the Judiciary Committee hearings. And the one thing that really became crystal clear to me is this. Gun control laws, and this is a gun control law. You can couch it the Rhode Island Families Act, Protect Rhode Island Families Act, it's a gun control law. Good or bad, that's what it is. Gun control laws are wildly misunderstood by the public. This legislation is flawed, and I think anybody that understands the legal system really well, I think most people in this room deep down, even if you are passionately anti-gun and see this as a stepping stone to something else, know that as written, this is a flawed piece of legislation. Nobody's defending domestic abuse. People are defending people's constitutional rights. This is not a good bill. I'm not going to belabor all the reasons why, but I'm talking more to the public now. People who are interested in gun control issues, whatever your philosophical point of view may be, across the spectrum, before you really delve into these things, understand the laws and the proposals that are being made, because there's more misinformation, in my opinion, pro, con, whatever, on gun control laws than any other issue in this entire country, state, federal, or local. So please understand it before you make your decisions and do what you ever think is right to do for your constituents. Thank you.
I want to make it perfectly clear to everybody in this room and outside of this room that those folks that are opposed to this bill are not trying to protect habitual domestic abusers or dangerously violent domestic abusers. What we are trying to protect is law-abiding citizens' right to own a gun, and that is protected by our Constitution. The problem with this legislation is that it does not target habitual or dangerously violent abusers. It removes judicial discretion, and that's the discretion, that's the system we are using now. A judge knows if somebody is habitual. They know if they've been before them before. They know the circumstances of the restraining order. They can use their discretion to take someone's gun away. No one who opposes this bill thinks that domestic violence is a good thing. But judges can do it now. This bill removes that discretion. I just think it's unbelievable that when we said jail time was removing a constitutional right, that we forgot that a judge does that. He uses his discretion. Searches and seizures, we are protected from unreasonable searches and seizures. That's what a warrant is for. And guess what? A judge uses his discretion on that. In civil proceedings, too many people will plead nolo contender because they don't have the money for a lawyer. And that removes judicial discretion. And that's where this bill goes too far. The system works now. Because a judge can do this, can remove guns from a habitual offender. It is very misleading and offensive to be charged with protecting horrible people because we're defending a constitutional right. Thank you.
We heard that the Patriot Act in 2001 was applauded by everyone. Who said, Patriot Act, we all applauded it. There was no such applause for the Patriot Act. There were screams from every building that this is the biggest violation of our civil liberties in the history of this nation. The Democrat Party, the Republican Party, many people got up and argued that. We don't take the government putting their jackboots on our throat and stripping us of our rights and say it's okay, ever. We also heard we can take guns away from abusers with this bill, and we should. No one, despite the inclination to believe otherwise, no one will disagree that people who are abusers should not have firearms. That's not what this is about. This is about, again, what this bill does. And it's not very narrow. It's very broad. It's the exact opposite. An accusation against someone and an application for a restraining order. That's all that's needed. No finding of fault. No criminal wrongdoing. That is not an abuser. That is not the habitual criminal violators. Those folks are already in this. Our laws deal with that. Not a single case was presented to anyone in this body or found by anyone who's researched it to support the claim that people who have been subject to restraining orders in the state of Rhode Island violate them by using a firearm. Not one case, even from the very well-funded and well-researched opposition. None. It's never been an issue in Rhode Island. So we're going to cast this wide net. Because if we can save just one person, shouldn't we? That's a great argument, but it falls flat every time it's used. If we were concerned about saving one person, we'd have a fireman and a policeman in front of everybody's house. You have to balance it. We have civil rights. We can't flush them down the toilet on an accusation. Make no mistake, that's exactly what this bill does. Precisely what this bill does. The courts are opposed to mandated actions. They've expressed that to us every year when we go to their reception. We hear it all the time. The police are opposed to this because it places an undue burden on the police department. Over 30,000 criminal cases go through the court system in the state of Rhode Island, many of which are domestic cases involving exactly what we're talking about here. How are they going to catalog that kind of personal property after it's stripped from its rightful owner on an accusation? Let's come down to earth, put the hyperbole aside. We are taking a constitutional right away from people simply because someone accused them of something they may not have done. That's the bottom line of this bill. Thank you.